And for that part of the process, I want to bring in Cece Moore. She is an investigative genealogist. She's known as the DNA detective. She's helped identify more than 200 violent criminals. So Cece, this is tricky and it's fascinating, but you got this massive family tree, maybe 30 or 50 or 100 members of a family. Where do you start? How do you weed out which members of the family are innocent and which one is the one that matches what they found at the crime scene?
Well, taking a step back, it's not quite as simple as you just laid it out, because Ancestry DNA and 23andMe, which are the largest databases by far, actually bar law enforcement from using them. And so we are limited in this work to the two smallest genetic genealogy databases, which are GEDmatch and Family Tree DNA. And so we can only compare against a total of about 2 million genetic profiles. If somebody's DNA is being used for these cases, they have consented to that. In GEDmatch and Family Tree DNA, they have been notified that law enforcement is using the databases, and they have opted in or not opted out in one case.
So there, the opting part, that's the fascinating part, because I know that early on in the 23andMe and Ancestry, it was kind of open season until they freaked out and thought, oh gosh, don't get our company involved in this. And then it became an option for us, the customer, to say, yeah, I'm fine. You can pop my DNA into any database, or no, you may not. Don't we have that option?
No. Ancestry DNA and 23andMe will not allow law enforcement to use their database, and it has never been used for investigative genetic genealogy, to my knowledge. And I'm pretty dialed in. I think I would know.
Does Escobedo ring a bell? Miranda? I mean, you must have heard of the Fourth Amendment. What I'm saying is that man had rights.
Well, I'm all broken up about that man's rights.
You should be. I've got news for you, Callahan. As soon as he's well enough to leave the hospital, he walks.
What are you talking about?
He's free.
And you're letting him go?
We have to. We can't try him.
And why is that?
Because I'm not wasting $500,000 of the taxpayers' money on a trial we can't possibly win. The problem is we don't have any evidence.
Evidence? What the hell do you call that?
I call it nothing. Zero.
Are you trying to tell me that ballistics can't match the bullet up to this rifle?
It does not matter what ballistics can do. This rifle might make a nice souvenir, but it's inadmissible as evidence.
And who says that?
It's the law.
Well, then the law is crazy.
This is Judge Bannerman of the Appellate Court. He also holds classes in constitutional law at Berkeley. I've asked him for an opinion. Your Honor?
Well, in my opinion, the search of the suspect's quarters was illegal. Evidence obtained thereby, such as that hunting rifle, for instance, is inadmissible in court. You should have gotten a search warrant. I'm sorry, but it's that simple.
A search warrant? There was a girl dying.
She was, in fact, dead, according to the medical report.
But I didn't know that.
The court would have to recognize the police officer's legitimate concern for the girl's life, but there is no way they can possibly condone police torture. All evidence concerning the girl, the suspect's confession, all physical evidence, would have to be excluded.
There must be something you can get him on.
Without the evidence of the gun and the girl, I couldn't convict him of spitting on the sidewalk.
CC, they came at you today. 4 witnesses. Witnesses 2, 3, and 4 were all supposed experts in genealogical DNA or whatever you call it. And they were attacking the process, that this was not done the right way and to different degrees should be excluded. What do you think?
Well, I didn't see how any of it was directly relevant to this case. None of them had any information, as far as I could tell, about how the investigative genetic genealogy was done in the Kohberger case. If they are questioning genetic genealogy's reliability, which it certainly appeared that they were, we have proven its efficiency and its reliability in over 800 cases now, where a DNA sample has been positively identified, at least in part, thanks to leads generated through investigative genetic genealogy. But like I always say, all of this really is irrelevant because it is simply a tip. It is not going to be used against anyone in a court of law. It is not evidence. It's not exculpatory. And so in the end, it's the DNA match that they got to the admissible genetic evidence that is going to be used against him.
The fruit of the poisonous tree doctrine is a legal doctrine which states that if the source of evidence is tainted due to a violation of constitutional rights, then that evidence, along with anything that is obtained as a result of that tainted evidence, has to be suppressed and cannot be used against the defendant in a criminal case. The classic example is an illegal search of a car that leads to some sort of evidence, say, of drug sales. That lead, that drug sales information evidence that was obtained illegally, is suppressed, and so is everything that was obtained because the officers found that information.
This film is a project of the Leonore Annenberg Institute for Civics of the Annenberg Public Policy Center of the University of Pennsylvania, in partnership with the Annenberg Foundation Trust at Sunnylands. Citizenship is every person's highest calling. The case of Mapp v. Ohio might seem like it was made for TV. Look at this. It's got a bomb, gambling, a world-famous boxing promoter, a determined heroine, and a cop who breaks the rules when they get in his way. But to people that study the Constitution, what makes Mapp v. Ohio really exciting is the Fourth Amendment.
Fourth Amendment is vital.
The Fourth Amendment requires that we be free from unreasonable searches and seizures.
The Fourth Amendment gives us a right to privacy, preventing government from searching or taking us, our homes, papers, or property without a good reason. It says so right here. The government has to show probable cause, that is, a good reason to suspect that you've done something wrong. And in many cases, it has to issue a warrant to put its reasons and what it's looking for down in writing.
That protects you from the police or from the government generally invading your privacy.
It really is an essential right of the people.
But there's a problem. The Constitution doesn't exactly say how to make sure this right is enforced. Back in 1957, Dolly Mapp thought she knew.
I had to stand up for my rights.
She did. And when police rang Dolly Mapp's doorbell, they had no idea they were about to open the door to a new era in American civil liberties. But they did have a pretty good idea they were going to get a fight from Dolly Mapp.
I could not just ignore this. My freedom was at stake.
Before dawn on May 20th, 1957, a small bomb went off at this house in Cleveland, Ohio. The owner of the house, Donald King, wasn't hurt, but he was pretty scared, and he called the police to investigate.
Don King was well known to law enforcement. He was suspected of running an illegal gambling business known as the numbers game.
The numbers game was essentially a lottery long before lotteries were run by states. In 1957, this kind of gambling was highly illegal. Sometimes that led to violence between the people called clearinghouse operators.
The clearinghouse operator is the one who sort of oversees the whole operation.
And Donald King, who later became world famous as Don King, promoter of Muhammad Ali and other boxing champions, not to mention that hair. Young Donald King had a record and a number of encounters with police over the numbers game. So when his house was bombed, he called the division of the police department he knew personally.
He called the Bureau of Special Investigations.
This division was in charge of cracking down on the numbers game, and it was headed by Detective Carl Delau. Carl Delau was not just an 11-year veteran of the Cleveland Police Department, but a World War II vet as well. A hard-nosed cop, he didn't like people he thought were connected to the numbers game, and he figured King's house was bombed by one of them.
When the police were investigating this, there were a number of other racketeers who they suspected of involvement in this bombing.
3 days after the bombing, Delau got a tip that a possible suspect might be hiding in a house on Milverton Road. He knew who lived there, Dolly Mapp.
He had suspected that she was involved in gaming for some time.
Dolly Mapp.
Most of my friends called me Dolly. Very few called me Dolly.
Okay, Dolly Mapp was known around town. Tough, outgoing, and driven, she was married to local boxing star Jimmy Bivens. Later, she was engaged to world light heavyweight champion Archie Moore. She owned this house in Shaker Heights, one of Cleveland's nicest neighborhoods, living upstairs and renting out the basement. She was a fighter then, and she's a fighter now.
She's a very determined person. She doesn't suffer fools. She's very forthright. In many respects, she was a woman ahead of her time.
I took care of myself. I'm not going to sit down and let you know when you run over me.
Sergeant Delau knew this wasn't going to be easy. He told the two officers with him,
I know Dolly, and she's not going to let us in this house.
But they believed that the suspect was there. When they showed up at the house, they just said, we'd like to come inside and talk to you.
And Ms. Mapp said to them, do you have a search warrant?
Most of us have learned about search warrants from TV or the movies, but a warrant actually comes from the Fourth Amendment.
A search warrant must be very specific about what is to be searched, where is it going to be searched, and who is going to be searched. And it must be signed by a judge who is neutral, who can read the document and determine that probable cause actually exists for going into this person's house or car or place of business.
The whole idea of a search warrant is to get a second opinion from a neutral and detached magistrate about whether the police really have enough cause to search your home for whatever they're looking for.
And so that piece of paper, really does represent the Fourth Amendment.
To the framers, liberty was not a vague notion or something to be fought for far away from home. It was just the opposite. Liberty was urgent. It was deeply personal. The framers understood the importance of liberty exactly because they had experienced tyranny inside their own homes.
The Fourth Amendment was a response to a specific grievance.
The British had what was called the writs of assistance. And the writs of assistance gave British troops the right to just search anybody's house and look for contraband, look for all kinds of different things.
And so it was very much a blank check for people to engage in searches. And people were quite alarmed at this.
So the whole idea of the illegal searches and seizures was something that was tremendously important to the framers. I've always had my own suspicion that part of it was because probably a lot of them had seditious literature in their basements. They were revolutionaries.
Okay, now you've probably heard of this. Boston Tea Party was an early symbol of resistance to British rule. But 12 years before that, in 1761, Attorney James Otis fought the British Empire over writs of assistance in a Boston courtroom.
A man's house is his castle.
He was arguing about the importance of privacy, about why it was just offensive to people and to democracy itself to allow the government to have that much power that they could just search and seize at will.
These writs of assistance, if declared legal, would totally annihilate this sacred human right.
Lucky for us, future President John Adams heard the real Otis, and not this actor.
A man's right to his home is derived from nature.
After hearing Otis make his final argument, Adams said,
"Then and there, the child liberty was born."
That's how central the idea of restricting searches and seizures is to American democracy.
The idea of someone knocking on the door or breaking down the door at 2 a.m. To toss you out of bed, possibly to take you into custody without ever telling you why or showing any justification, was a kind of power that needed to be reined in, because in order to have a successful self-governing society, individual citizens have to understand that they are in charge.
So the colonials put in the Fourth Amendment the right to be free from unreasonable searches and seizures. Now we have come to understand that an unreasonable search and seizure is something that's done without a warrant. So the judge decides whose home gets to be invaded.
But look at this. Unreasonable, warrant, probable cause. What's missing from the Fourth Amendment is a way to make sure the police obey it. Not only that, most crime is handled by local police and state courts, and several states never enforced the use of warrants, so police just stopped getting them. If they searched a house without one, that evidence would be used in a trial anyway, so...
Police officers, knowing that a warrant was not necessary, would conduct warrantless searches because they knew that there were no ramifications for their actions. And so there was nothing to deter them from acting in an illegal fashion.
So when Sergeant DeLisle rang Dolly Mapp's doorbell, he didn't have a warrant, and she didn't invite him in. She believed she had rights to protect her.
I haven't committed a crime, so why are you here? I called the lawyer.
She was a legally sophisticated person. She went back, she talked to an attorney, and the lawyer said, don't let them in if they don't have a warrant.
So the police went away. 3 hours later, they come back again.
They broke a window and then they pried open the door in order to gain entry to the house.
And when I looked up, they were in my house.
So it's important to recognize that Dalry had not let them in the home. In fact, she continued to tell them they were not welcome, but they entered the home anyway.
And they say, we have a search warrant. And Dalry Mapp says,
may I see the warrant?
So the police officer there pulls out a piece of paper and waves it in front of her and starts putting it back.
She grabbed the piece of paper and put it down her blouse.
Turned out that paper was not a warrant. The police never got one. At this point, though, they handcuffed Dolly Mapp and searched her house. They actually found their suspect downstairs, so he was there, but he was also released the next day because it turns out he had nothing to do with the bombing. They didn't find anything else related to the bomb, but in an upstairs dresser, the police found some pornography that Dolly Mapp says was owned by one of her former boarders.
They found some materials that led to her being prosecuted for obscenity, possession of obscene materials. One of the things they found up on the second floor were erotic comic books.
Okay, take a moment. It's okay to giggle. Even Dolly and one of the officers laughed that day.
I didn't think I was in any trouble. The officer enjoyed looking at him himself.
But the laughter ended quickly. Although they didn't charge her with anything having to do with the bombing, Dolly was charged with possession of obscene materials. For having this in her home, even though it wasn't hers, she was facing 1 to 7 years in prison and a fine of up to $2,000.
It's astonishing. It's a terrible law. The Ohio law prohibited possession of obscene material, so it was quite a broad anti-obscenity law.
At her trial here in the Cuyahoga courthouse, Dolly and her attorney, A.L. Kearns, tried to have the evidence thrown out or excluded. They claimed the search was unconstitutional since there was no warrant. That's called the exclusionary rule.
The exclusionary rule is a rule that says if the police obtain evidence in violation of your Fourth Amendment rights through an unreasonable search or seizure, that evidence can't be introduced against you in a prosecution.
The exclusionary rule in the American legal system goes back to 1914 in a case called Weeks v. United States, where the court said that if a federal law enforcement officer found evidence illegally, that evidence could not be used against the defendant.
This was tremendously important because it was the first time that the Supreme Court recognized that the Fourth Amendment sets out certain rules, and that if the police don't follow those rules and they obtain evidence, that evidence should not be used.